Justice Lawrence M. Mugambi, Honorable Justice Bahati Mwamuya, Petition E-083-25, Honorable Lady Justice Martha Koome versus the Judiciary Service Commission. Kindly use the mic nearest to you when addressing the court, and remember to state your name whenever you're addressing court for ease of transcription.
Good afternoon. Before senior counsel, you talking.
Thank you, Lord.
Let me start by apologizing. We have really overstayed, but I believe you are told that one of us was involved on the bench. We were waiting for him. I came also very early. I was here at 9. Been waiting for my colleague, Justice Mugambi. So we are ready now to start. After the forum, we are going to do some inquiry about the issue of one of the party petitioner who is now deceased. But let's first have the forum of those people who are present.
Thank you, my Lord. For the petitioners, George Oraro appear with James Chepkwony and Alphonse Oduor for the petitioner, Chief Justice Lady Justice Martha Koome. Mr. Andrew Musangi was here, but he's just left for an urgent matter, and his brief is being held by Ms. Beth and Ms. Shreya Sheth for Lady Justice Njoki Ndung'u. Dr. Ken Nyaundi and Mr. Dudley Ochiel and Ms. Faith Lukoy appears for Justice Isaac Lenaola. Mr. Kenvin Ouma, Kenvin Ouma appears for Honorable Justice William Uko. Mr. Kipkogei appears with Mr. Mele and Mr. Maiga for the 5th respondent. No, I see here that it is Kipkogei and Alex Boyer. Kipkogei and Alex Boyer for the 5th respondent, Justice Dr. Smoking Wanjala. Mr. Jeff Akere appears for the 6th petitioner, Lady Justice Philomena Mwilu. And Mr. Isaac Odhiambo appears for the late Justice Ibrahim Kadir. Now for the respondents, Mr. Isa Mansour appears with Ms. Ahomo and Mr. Samuel Mbatai and Ms. Fahima Jaffa and Ms. Wanja Wanjuki for the first respondent. Mr. Emmanuel Bitter appears for the second respondent. Now, for the interested parties, Mr. Nelson Harvey was appearing in person, but I don't see him around. I don't know whether he is online. We'll find that out. Mr. Christopher Rosana appears for the second interview party, and I didn't see him around.
He's not present? For the first and second, they are not present?
They are not present.
Interested parties.
Yes. Then Mr. John Kisigwa appears for the 3rd, 4th, 5th, 6th, and 7th interested parties. Mr. Willis Oluga appears for the 8th, 9th, and 10th interested parties. Mr. John Kisigwa is holding brief for Mr. Onderi Nyabuti for the 11th, 12th, and 13th interested parties. Ms. Mulwa appears for the 14th and 15th and 24th interested parties. Mr. Duncan Okach and Mr. Amutavi and Ms. Marley appears for the 16th and 18th interested parties. Mr. Odhiambo Ndege appears for the 17th interested party. Another friend, Mr. Evans Ogada, appears for the 19th interested party, who is Mr. Tuju. Ms. Baraza and Mr. Malay appears for the 20 and 21st interested parties. Mr. Kiragu Watuta appears for the 22nd interested party, that is the Kenya Judges and Judges Association. And Mr. Joshua Malizo Nyawa appears for the 23rd interested party, that is Katiba Institute. Mr. Joshua Malizo Nyawa for the 23rd interested party, Mrs. Katiba Institute. Lord, that is the order of appearance today, and this matter was placed today for highlighting and submissions, and as Your Lordship indicated before we start, we have to deal with the issue of our deceased colleagues, Justice Ibrahim. Lord, I would request that we at least observe 1 minute's silence in his honor, if you don't mind.
Okay. Before we start the highlighting, can you first get the advocate representing the late Ibrahim, Justice Ibrahim?
Good afternoon, Your Lordships.
Yes.
My name is Odhiambo Isaac. I do appear for the late judge, that is the 7th petition. Now,
yes.
Your Lordship, we did write to the court of a letter dated the 26th of February 2026, formally informing the court of the position that we find ourselves in and in relation to the petition that is pending before you. We believe that looking at the mandate of the JSC and Article 168, I believe those rights are proven personal in terms of any proceedings before it. Without that particular petitioner, we believe that it cannot be sustained. The Lordship will be seeking your directions in the matter, noting that also we had already complied with the directions of the court fully. We believe that the petition, in our considered opinion, abates I do say that we'll be seeking your directions in the sense that we had complied with the court's directions, and the matters which are before you primarily focus on matters of law, so that if the court would want to consider the submissions that we had already filed, it can take that position and advise the parties. Therefore, we'll be seeking your directions in terms of moving forward with our petition.
I think we'll have to start with a minute of silence as proposed by the senior counsel, And then you give direction after that, yeah?
Much better.
Okay. Okay. Seated, huh?
Much better.
The amended petition dated 10th June 2025 have abated following the demise of the 7th petitioner. Consequently, the proceedings shall progress with the 7th petitioner as discharged and counsel for that party is excused from further participation. Documents filed while on record shall not be considered.
Much better, Your Lordships, and we'll have a lovely afternoon.
Thank you.
And we are proposing that the petitioners each can be able to highlight within 10 minutes. And then JSC about 20 minutes. And each of the other interested parties about 5 each, because we are very many. Does that work? Senior Counsel?
I was suggesting that the petitioners be given 15 minutes.
15.
If possible. And I think we'll approach it from the position that whatever has been covered, there are other petitioners will not cover it. So they will spend less and less as we go on, if that is possible.
And if you propose you bring the first one, you are one starting from the side of the petitioners, eh?
Yes, ma'am.
If the other petitioners can agree, you take 15, then the others 10, 10, 10. That all?
That's fine.
Then Mr. Issa?
That's fine. I can take 20 minutes. That's fine.
15 or 20?
15 or, yeah, that's fine.
You can take 15.
I'll try to compress within 50. We have 5 comprehensive submissions. I can try to take 15 as well for the judicial service submission. I'll just take the time.
Who is the second respondent?
Mr. Malone, I'll give you 5 minutes. Just can take minutes.
Then you can take, if it is only Mr. Issa, you can take about 15, 20?
That's fine. That will be okay.
So 15. Then into the parties, we are not oppressing you, but we want you also to be very brief. Because you have your submissions that you have to read through. But you take the minimum, you can maximum 5, is it? Okay? Any objection?
Sorry, Your Lordship, I have instructions here to go brief for Mr. Nyamodi and Mr. Okat. I don't know if that will be factored in terms of time allocation. I intend to take about 10 minutes max.
For both? For
Yes.
5 for you and for Mr. Nyamodi?
Including my own time.
Okay.
So I will take maximum 10 minutes for the 3 parties.
Yeah, once you start, you remind us,
Most of
so
them.
that you know that you're going for both.
Most of them.
And our brother judge. Okay, we will start now, and our NEMA is going to vote once your time is over, so that they'll be able to keep time. NEMA?
Yes.
Sawa?
Yes.
Okay, proceed. Senior Counsel.
I will start by first Mr. Nelson Harvey. Sorry. There were two petitions before the first respondents under Article 168. The first one was by Nelson Harvey, together with Ms. Angawa and Senior Counsel Amenase, who he claimed to be representing, and was on grounds that they were condemned without being heard in the case of AG versus D. The other in the same petition was that the CJ was responsible for the unconstitutional regulations which were made by the Supreme Court for punishment for contempt. And lastly, that by letter of 18 January 2024, the Supreme Court erred in barring both himself and Abdullahi on appearing, senior counsels, on appearing before the Supreme Court. Lord, the letter of 18 January was only targeted towards senior counsel Abdullahi. The first interested parties petition, Mr. Rosanna, is on the grounds of removal of the Chief Justice for responsibility as the presiding judge of the Supreme Court in the communication made by the registrar and dated in the letter of 18 January 2024. Substantive submissions have been made, and I humbly rely on the same for the purpose of prosecuting this constitutional reference. And on substance, the first is was the issue of jurisdiction, and your Lordship had interlocutorily dealt with that. And I do believe that issue is resettled. And indeed, both the Supreme Court and the High Court have fully settled the same issue, not only on your ruling, but in the ruling by the Supreme Court in Chitembwe and on the Mwilu decisions. The JSC contends that its mandate as an independent commission, pursuant to Article 172, read together with Article 249(1), and the fact that it is by Article 252, 1A, conducting an inquiry, it has full constitutional powers to inquire into any matter concerning the judiciary. This is with disregard to the very clear provisions of Article 2(1) and 2, binding every organ of the state to the provisions of the Constitution, and the right granted under Article 258(1) for any person who feels that the Constitution is always about to be violated to come to this court. And the sole power given to the High Court by Article 165(3) to be the only organ of the government who will inquire into constitutional violations. The issue is therefore settled, and that the submissions do not take this court any further on why the ASC would have indulged on this petition to dismiss all the judges of the Supreme Court. Now, the petition before the JSC is with regard to the Supreme Court's decisional and administrative powers. It is against their judgment and order in respect of recusal, and the notice of direction by the Registrar of the Supreme Court pursuant to Rule 6 of the Supreme Court rule that the complaint was predicated. This disregarded the very fundamental structure of our Constitution, which commenced with very detailed submission and consultation with the people. And as will be clear from the final report of Constitutional Review Commission at paragraph 13.5.4, which stated very clearly that the people of Kenya wanted a judiciary which is independent and free from interference by any person or organ, both of state or otherwise, and both institutionally and decisionally. So it only does not cover the judicial actions which are decisional but also administrative. The people of Kenya, in their own wisdom, also wanted the Supreme Court to be the final court, whose decision would be final and whose decision would bind all parties. These hallowed virtues were incorporated into our Constitution by enactment of Article 161, securing the independence of the judiciary by securing the judicial authority to be only subject to the law and the Constitution, and not subject to the control, direction of any person or authority. Further, the position of members of the judiciary was also secured by ensuring that they are not liable in an action or a suit in respect of anything done or omitted to be done in good faith in the lawful performance of judicial functions. This was amplified by the provisions of the Evidence Act, and therein lies the anathema of this complaint before the Judicial Service Commission by Section 129, which grants a judge or a magistrate absolute privilege only subject to an order of a superior court not to answer any question as to their conduct in court. And a judgment or a direction given pursuant to the rules is a conduct in court. To further secure this sanctimonious position of the Supreme Court, the makers of our Constitution, by Article 163, constituted the Supreme Court to be properly constituted only when it is composed of 5 judges. And therefore, when a decision is made by the Supreme Court, it is a decision of the Supreme Court as constituted by the Constitution, which was intended to secure it. Constitution even went more than that. By Article 163(7), it made these decisions binding on all courts and thereby conferred the principle of finality. The said article was made in public interest so that in the interest of the state there will be an end to litigation. And this is based on the Latin mantra, which is interest republicae ut sit finis litium. The principle of judicial independence is the anchor of the rule of law universally accepted. And I will, in the course of this submission, refer you to the other jurisdiction and how it is secured. Now, the first respondent scoffs at the concept and retorts that this honorable court does not have jurisdiction to direct the manner in which JSC should hold the judiciary accountable. But the judiciary can only be held accountable subject to the provisions of the Constitution, not independent thereof. Granted, the JSC is an independent commission established under the Constitution, but like every other organ established under the Constitution, it is subject to the Constitution, not above the Constitution. This Honorable Court has the jurisdiction to hear any question regarding the interpretation of the Constitution, and more specifically relating to constitutional powers of a state organ. In this case, beginning with whether there is jurisdiction under Article 168 to remove a court, and what would be the consequence of JSC negating the principle of finality. So those are the two principles, issues before you. One, they want to use the right of removal of a judge to remove the Supreme Court for decision made by the Supreme Court. Do they have that jurisdiction? And two, do they have jurisdiction to review a decision which by Constitution is deemed to be final and binding in all courts? On trying to justify that there cannot be constitutional protection for judicial impunity, and therefore the Judicial Service Commission is entitled to go into decisions if it thinks there is impunity, they have relied on the case of Bellevue Development Company and Francis Giconyo and others. But that was not a case of a complaint before Judicial Commission. It was a case before a court. And a court has the powers to review if it is a concurrent court, and it falls within the review jurisdiction. And the Court of Appeal has the right of going through a decision to review and arrive at a different conclusion in all cases. Those are jurisdictions granted by law in accordance with statute and pursuant to the Constitution. But the Judicial Service Commission, in exercising its removal powers, does not have that jurisdiction. It is for this reason that Justice Jackson, in the case of Brown and Allen in the U.S., had the following to state of the Supreme Court in the U.S. We are not final because we are infallible, but we are infallible because we are final. A decision of the Supreme Court is final and infallible. And if you intend to review it, then the only organ which can review it is the Supreme Court itself. But if that is not suitable to the people of Kenya, the path is to amend the Constitution. It is not to go through judicial review, Judicial Service Commission, to remove all the judges of the Supreme Court, as the first respondent tried to do in this case. The first respondent has relied fully, very heavily on the case of Uganda in Attorney General vs. Nakibule. This is a case by the Supreme Court of Uganda, in which it was stated that the concept of judicial immunity is applicable only to judicial acts properly so-called, and not where there is an accusation of impropriety. The same court proceeded to find that it is not the correctness of the merit or the merit, but the improper exercise of judicial power that would be subject to investigation. This was a case of removal of a deputy registrar and not a removal of a Supreme Court. That was an individual judicial officer, not a judicial institution. And further, in this case, what we are dealing with is the merits of the decision of the Supreme Court, and that is the basis upon which the complaint has been made. Nakibule decision, however, looked at in larger context, subordinates the exercise of judicial authority to the exigencies of a Judicial Service Commission. Indeed, it was the intention of the framers of the Constitution that the exercise of judicial authority would be subject to overriding, would not be subject to overriding powers of the respondent. And if the intention was otherwise, then there would have been a qualification to Article 160 or Article 168, and there is no such qualification. Further, the Nakibule decision upsets over 100 years of precedent in various jurisdictions, beginning with the case of Anderson and Gori Lorry, which I'll refer you to, which was a century before. And this is what is stated, that if one judge in 1,000 acts dishonestly within his jurisdiction to the detriment of a party before him, it is less harmful to the health of society to leave that party without a remedy than that.
You're just warning you, your time is over. You just concluded.
Let me conclude. So, it is on this that you will find that in Brown and Allen, you will find it at page 386 of my submissions. The U.S. upheld the concept of judicial independence. So was Canada in Magellan and Hickman, page 3182 and 320 of my list of authority. That is in Canada. So it was Valente versus the Queen. That is page 377. That is, I've told you, U.S. now is Canada. And then even the Supreme Court of India has upheld the same in Supreme Court Advocates on Record versus Union of India, page 431. We are being asked to depart from that on one Ugandan decision on a deputy registrar. I just had one statement to make on the issue of fair administrative action. And on fair administrative action, what I wanted to say is that, my lord, fair administrative action is a constitutional provision under Article 47. And by the Fair Administrative Action Act, in the absence of any rules, the applicable legislation is the Fair Administrative Actions Act. And at worst, that is what, yes, you ought to have complied with. And under that act, they were nevertheless bound to specifically state what offense was being relied upon and the facts which were being relied upon, which they didn't. Instead, they are saying that although they were required to make regulation, they are saying those regulations are permissive. Yet, those are the regulations required in order to satisfy a constitutional fundamental right. And therefore, without the regulations, particularly in this case where there are at best two competing provisions in the Constitution, which is independence of judiciary and the power of removal, there ought to have been a clear analysis by JSC whether a complaint against a judgment is a matter within their jurisdiction. And in my humble submission, it is not, because Article 168 is very clear. It refers to a judge and doesn't refer to a court. And secondly, it does not refer to judgment, it refers to conduct. And conduct other than judgment is clearly protected under Article 160. That was my humble submission.
Thank you. We hope others you
decide which submissions we wish to rely on. Yes, Your Lordship, the petition before you presents a constitutionally fundamental question on whether the first respondent may interrogate the merits of judicial reasoning under the guise of disciplinary jurisdiction. Your Lordship, this matter is not about whether the Supreme Court was right or wrong. It is about institutional design. It is about whether the Constitution permits a disciplinary body to sit and review judicial reasoning. Your Lordships, if that boundary shifts, then the architecture of Article 160 also shifts with it. Three issues then arise, which I wish to submit on. Number one, whether the first respondent JSC 35 of 2024, which appears at pages 25 to 139 of the second petitioner's bundle, annexed as NSN 1. Your Lordship, a reading of the petition will reveal that the complaint challenges, 1, the Supreme Court's recusal rulings delivered on 6th of October 2023 and the one delivered on 7th of November 2023. 2, the JSC petition number 35 also challenges the application of the doctrine of necessity. It also challenges the management of proceedings by the Supreme Court in Civil Appeal number E012 of 2023. Your Lordships, at pages Supreme Court Civil Appeal number E012 of 2023. Your Lordships, at pages 60 to 80 of our bundle, there is the supporting affidavit that has been sworn by Raphael Tuju in support of the petition, and it clearly contests the reasoning adopted by the Supreme Court. It is inviting the Commission, the JSC, to interrogate its correctness. Your Lordship, on the same breath, there is also JSC petition number 3 of 2025. The petition also challenges, 1, the judgment of the Supreme Court in Attorney General and others in the AG versus David Ndi and 79 others. And also, it challenges the recusal, the decision by the Supreme Court to recuse itself on 23rd of January 2024 in petition number 17 of 2022. Your Lordships, a reading of the petitions will reveal that there is no allegation in either complaint of, 1, mental incapacity of the judges. There is no complaint of bankruptcy. There is no complaint of corruption. There is no complaint of personal misconduct. The gravamen of both complaints is disagreement with judicial determinations. Your Lordships, Article 168(1) of the Constitution sets out exhaustive grounds for removal of a judge. The framers deliberately enumerated the grounds. They did not include unpopular decisions. They did not include controversial reasoning. And Your Lordship, it's our humble submission that where the Constitution speaks in exhaustive terms, neither a statute nor administrative interpretation may enlarge the list. Article 172, Your Lordship, empowers the first respondent to receive and investigate complaints. But that power has to be read harmoniously with Article 168, which is substantive. Your Lordship, the gist of our petition is on the issue is that the first respondent cannot investigate what cannot constitutionally ground removal. We submit that whether they are recusal rulings or judgments, those are core judicial functions. If Your Lordship were to, if Your Lordships were to ask when jurisdictional error arises, it arises immediately upon assumption of power not conferred by the Constitution. If absent at inception, then the entire process is a nullity, regardless of how carefully it proceeds thereafter. So that the injury by my client lies in being subjected to an ultra-vires process. Article 160 does not protect comfortable decisions. It protects difficult ones, and we urge this Honorable Court to uphold that provision. On the second issue, I wish to submit on whether, on the absence of gazetted regulations and its import on my client's rights. Your Lordship, in petition number 34 of 2014, the case of Gladys Bosch-Cholet versus Judicial Service Commission, in the said decision, Your Lordship, there were directions by the Supreme Court that the first respondent publishes and publicizes its disciplinary procedures in the Kenya Gazette within 90 days. Your Lordship, as we speak, I don't know how many years we are looking at, but that directive has yet to be implemented. At paragraph 63 of the first respondent's replying affidavit, the Commission admits that regulations governing disciplinary procedures against judges have not been submitted to the National Assembly. That is not in contest.
Excuse me, 1 minute to go.
Yes, Your Lordship. There are detailed disciplinary regulations governing magistrates. There are none governing removal of superior judges. Your Lordships, removal is the gravest constitutional sanction, and Article 47 requires administrative action to be lawful, reasonable, and procedurally fair. We submit that without the regulations, the proceedings before the first respondents remain opaque and lack transparency as required of the Commission in the Constitution. Your Lordship, I'll leave the rest for my colleagues to tackle, but we are praying that the court finds merit in our petition and grants us the reliefs as sought. Those are the submissions by the second petitioner.
Now the third petitioner. I will start with the easier part of my client's petition, and that is the fact, my lords, that in the dairy petition, petition number 35 of 2024 before the JSC, the Director of Dairy the fourth interested party, I think in E087, Mr. Raphael Tuju, in an affidavit sworn on 4th March 2025, reiterated the fact that my client, Justice Isaac Lenaula, was not on the bench that decided the petition before the Supreme Court, which gave rise to this petition, and therefore ought not to be in the proceedings before the JSC. If my lords look at that response by Raphael Tuju on the third paragraph, he references a letter which is on page 9 of his affidavit, in which he says that the inclusion of Justice Lenaula is erroneous and that they have no complaint against the Honorable Justice Lenaula.
Zeal the drones. That petition against him or his name from the JSC.
He has not withdrawn it.
He just stated in the affidavit.
In fact, the dishonor in the conduct of the JSC is a right from the Secretariat to the committee and the full JSC. None of them read this paragraph or this letter saying that Justice Lenaula ought not to be in these proceedings. We will therefore respectively, my lords, seek an immediate dispensation of Justice Lenaula from these proceedings, at least the petition by Dari. On the Harvey petition, if I were permitted to call it that, my lords, we filed the petition on the 21st of February 2025. The petition was supported or is supported by the affidavit of Justice Lenaula, sworn on the same date, and it is further supported by a further affidavit by Justice Lenaula, sworn on 21st March 2025. To that petition, my lords, we file our submissions and a case digest and a bundle of authorities dated 12th June 2025. Senior Counsel Raro and my learned friend Beth have spoken heavily on the issue of jurisdiction, but allow me just a minute on that. My Lord, under Article 160 of the Constitution, there is a clear pronouncement on the independence of the judiciary. My Lord, the grounds for removal of a judge set down under Article 168 are the grounds that empower the JSC to take action against a judge under Article 172. We submit, my Lord, that these articles of the Constitution are independent and self-effecting. Article 168 and Article 172 marry power with justice, making the operation of the JSC's power procedurally predictable, upholding the rule of law, and placing limits on the arbitrary exercise of power. There is little purpose or benefit, my lords, we submit, in providing for the independence of the judiciary if the JSC may seek an explanation from a judge on a ruling they have made. My lords, the claim by the JSC to review an order of a court undermines the constitutional order as settled in our 2010 Constitution. We need to remind ourselves, my Lord, that a constitutional order properly set out represents fundamental norms, customs, procedures, standards, and those procedures, my Lord, manifest the behavior and internalization of norms in a democratic constitutional order. Where a judge makes an error, the only remedy to that error is an appeal. But to whom then do you appeal when the Constitution makes the Supreme Court the final arbiter? You don't appeal to the JSC. The JSC has no power to review any such order. My Lord, we refer you to Section 3 of the Judicial Service Commission Act, as you may read it together with Article 172, and Section 3 and Article 172 delineate clearly the mandate of the Commission, and this mandate does not include the sitting and reviewing of a court decision. We refer, my lords, to the High Court decision in Mboya and another against the JSC and another, where the court pronounced itself in this manner. It is appreciated that the JSC cannot block anybody from complaining about the merits of the decision of judges and judicial officials. However, my lords, the court said, once the JSC determines that the complaint is about merits of a decision, it should drop such a complaint like a hot potato without even bothering to ask a judge or a judicial officer to respond to the complaint. This is the situation in which we are. The Dari petition, as against Justice Lenala, ought not to have moved before or after it was received in the JSC. There was no need to ask Justice Lenala to respond to a petition in which the petitioner himself clearly says, Justice Lenala is not a party to my complaint. My lords, I'll seek to run on a point which has not been covered, and that is the recusal of judges. My lord, can a judge be punished for their conscious decision to recuse themselves from a case? By a letter of 18th January 2024, the Supreme Court Registrar communicated to Ahmed Nasser and a copy to all parties in case number E017 of 2022, the decision of the Supreme Court to recuse themselves from that matter.
1 minute.
1 minute?
Yes, please.
My lord, judicial recusal addresses the need for impartiality in judicial proceedings so that justice is not only done but seen to be done. The ELC court in the case of Thomas Nyangeri Mogaka against Loslin Dola Ouko spoke in this manner. The judge said, I know that public confidence in the judiciary does not result from judicial perception of impartiality, but results from the public's perception of impartiality. Therefore, a judge believes that she is not biased is of little consequence to a recusal determination. It is our position, my lords, that it was within the power and authority of the judges of the Supreme Court to recuse themselves from that E017 matter. To this, my lord, 1 second, we refer to Regulation 21 and 23 of the Judicial Service Code of Conduct. my last sentence, my lord, is that the recusal is not an indulgence a judge grants to nervous litigants. It is a constitutional duty triggered by an objective risk to impartiality. Immunity for that act is equally constitutional. Together, they secure the twin pillars of justice, independence of the court, and the faith in the neutrality of the judges acting. We pray, my lords, that you find merit in the petitions and accordingly grant the prayer sought. We so pray.
My lord, my name is Ouma. I will be from Mr. James Ochimo, who is in the council for the court petition.
Petition number?
Number 90, E090345. Lord, our petition is dated 21st February 2025, supported by the affidavit of the fourth petitioner of the same date. And my client also filed a supplementary affidavit on 8th of July 2025 and written submissions on 17th November 2025. My Lord, I'll address two issues principally. The first one is these petitions deal with the threshold stage of the exercise of the first respondent's mandate. And my Lord, that threshold stage, as my senior counsel, Mr. Oraro, has given, requires JSC to conduct itself within the dictates of the law. But most importantly, it is to confirm and ascertain whether the petition as presented prima facie establishes a ground for removal of a judge. Now, there's a plethora of authorities. I do not want to go into each and every one of them. I want to invite the court to look at paragraph 24 and paragraph 25 of the response filed by the first respondent. My Lord, in that paragraph, the first respondent says that the petitions were tabled before the Commission on 24th January 2025, and upon deliberation, the JSC resolved that the petitions be served upon the Honorable Justice Ouko to enable him to respond. In paragraph 25, they say that the meeting was a preliminary evaluation of the petition to determine whether the issues raised prima facie justified either a need for a response by Honorable Justice Ouko or dismissal in the first instance. The focus of the Commission then was, should he respond? Not whether by a prima facie evaluation, this petition raises or satisfies any of the grounds in Article 1681 that would justify removal of a charge. My Lord, on the question of the merit review, again, I want to invite the court to look at the South African Judicial Service Commission Act, number 9 of 1994, and I want to invite the court to look at section 14, subsection 3, which is in pari material to Article 1681, section 15, and section 16. I want to invite the court to look at section 15, where there's a mandatory requirement upon evaluation. A complaint must be dismissed if it does not fall within the parameters of any of the grounds set out in section 14.4, which is in pari material with the Article 1681, and C, is solely related to the merits of a judgment or order. So therefore, the JSC is the person or the institution to process preliminarily all complaints against judges ought then to be guided to ensure that if a petition addresses any issue of merit or decision, then that is an issue that should be dismissed preliminarily. In my Lord, in section 16 of the South African Judicial Service Act, then says if the chairperson is satisfied that in the event of a lead complaint being established, it is likely to lead to a finding by the Commission that the respondent suffer from incapacity, is grossly incompetent, or is guilty of gross misconduct as included under section 14.4a, the chairperson must, 1, refer the complaint to the committee in order to consider whether it should be recommended to the Commission that the complaint be investigated, and in writing inform the respondent of the complaint. So So first is a requirement of preliminary evaluation, and then once you make a finding that there is an established ground, that's when now you inform the respondent to respond to the complaint. What does our JSC do? My Lord, they sit and say, should we invite him to respond, not whether the petition meets the threshold set up under Article 168, Sub-Article 1. My Lord, I just want to address the second issue of the publication of press release by the first respondent. My Lord, on 16th...
May I ask you one question?
Sorry, my Lord.
We are talking about preliminary evaluation and you have referred to the South African position.
Yes.
We have an equivalent to the Kenyan position, Kenyan laws.
Yes, my Lord.
Which one? You said which one?
That is at 168 sub-article 4. 3 a thread with 4.
So when a member of the bench asks a question, the time is paused. So if you wish to read it out, you can read it out.
Yes, my Lord. Now, my Lord, sub-article 3 of Article 168 says that a petition by a person to the Judicial Service Commission under Clause 2 shall be in writing, setting out the alleged facts constituting the grounds for the judge's removal. And sub-article 4 says the Judicial Service Commission shall consider the petition, and if it is satisfied that the petition discloses a ground for removal under Clause 1, send the petition to the President. My Lord, the Judicial Service Act does not have these precise provisions, but the courts have interpreted in about 6 or 7 decisions that this preliminary inquiry, as found in the Articles 168 sub-article 3 and 168 sub-article 4, then requires the JSC to establish that a ground has been prima facie basis justified or established. And that preliminary inquiry, therefore, includes before sending that petition to the judge to respond. It's a two-step process.
Okay, your time is back now.
Thank you, my Lord. My Lord, I want to invite the court to look at the UN basic principles on the independence of the judiciary, and I want to invite the court to look at principle number 17. That principle requires, one, that complaints against judges, one, be determined with expediency, and the most important aspect of that is the inquiry should be confidential. My Lord, the essence of confidentiality was determined by the US Supreme Court in the case of Landmark Communications Limited versus State of Virginia, and it is fourfold. The first one, it encourages filing of complaints by members of the public against judicial officers. Secondly, it protects judges from unwarranted complaints. Number 3, it maintains confidence in the judiciary. Number 4, it facilitates the JSC's work, the Judicial Service Commission's work. That then is the essence of confidentiality of proceedings. The first respondent does not dispute that it received these petitions, number 35 of 2024 and number 3 of 2025, long before. The last petition, that's number 3 of 2025, was filed on 13th of January 2025. On 16th of January, 3 days later, the JSC issued a press release. That press release has the list of the names of all the judges, that's the petitioners before you. And the meeting subsequent to that press release was held on 24th of January 2025. That's when the Commission resolved to invite the judges to respond to the petition. So therefore, the press release of 16th January 2025 was issued, my Lord, before the Commission sat down, before the Commission met to determine, one, whether these petitions first satisfy the threshold under 1681 to warrant the judge to be called to respond. The risk then, my Lord, that my client, the court petitioner, and the other judges and the other petitioners who come faced with is there's already public information and allegations against a judge that have not been processed as required by the Constitution. And the judge has had no notice of these petitions. My Lord, the principle of confidentiality is embodied in Section 30 of the Judicial Service Act, as read Rules 5, 9, and 12 of the first schedule, and Section 31, as read Rule number 9, and that therefore addresses the confidentiality of proceedings before the tribunal. While there is no direct or express provision on the confidentiality of proceedings before the JSC, to my Lord, based on the UN principles, independence of the judiciary as I've identified, and the decisions of courts, it is therefore important, if after a tribunal has been established, the judge is supposed to be protected, unless the judge requests so, would it not be more important for the institution of the judiciary to then ensure that these proceedings, at the bare minimum, are conducted with confidentiality and protect the dignity of the judicial officer concerned? My Lord, I want to invite the court to look at the decision of the Supreme Court of Ghana in Derry versus Tiger, PI, and two others. My Lord, that decision addresses two important aspects which I just want to highlight. One provides that common sense could even be brought to bear. Common sense could be brought to bear on this interpretation that the framers of the Constitution would not have intended that even before prima facie determination has been made, or before the committee has concluded its investigations, submitted its report, the whole world should be told the contents of a petition. That would clearly be defeating the purpose of the confidentiality and privacy that is required to attend to such proceedings. And the second is on the question of public interest. The Supreme Court of Ghana acknowledges this public interest, but then says the public is not completely denied the right to know, but certainly not before the prima facie case has been made.
1 minute.
Thank you, Lord. The JSC has done that. The response to the petition, Lord, there were next two press releases at page 108 to 110 of the replying affidavit. There's a press release of 5th March 2024 and a press release of 22nd November 2021. These press releases were issued after prima facie evaluation and after processing the petition. Why did they do that in this case? That is a question that we need to answer. And that is why we pray, Lord, that this petition be allowed with costs. Thank you.
Okay. Next one.
Hello. My name is Kipkogei. I appear together with Mr. Mbaya for the 5th petitioner, the Honorable Justice Smoking Manjaro. My Lord, I wish to associate myself with submissions made by some colleagues who submitted reports. And to only add a few items that I believe have not been covered. And before that, my Lord, our client's petition is dated 27th February 2025. We filed our written brief to the court dated 4th June 2025. Our submissions are in 6 parts. Part 2 to Part 6 have been addressed by my colleagues. I will address you, my Lord, on Part 1 thereof. My Lord, Article 163, Subarticle 3, confers on this court the power to hear and determine any question respecting the interpretation of the Constitution, including determining the question whether anything said to be done under this Constitution is inconsistent with it. My Lord, on 27th January 2025, the Judicial Service Commission wrote some 2 letters to the 5th petitioner asking him to respond and forwarding petitions seeking his removal from the bench. It is our submission, my Lord, that was action by a state organ which attracts the jurisdiction of this court. We make that submission, my Lord, because my learned friend Mr. Issa, in his response, has stated that the petitions before you are not right. We submit, my Lord, that those 2 letters constitutes a course of action which can trigger the invocation of the court's jurisdiction and Article 163(3). Sorry, 165(3). Sorry, 165(3), my Lord. So it's our submission, my Lord, that the petitions before you are constitutionally grounded and merited, warranting the grant of the reliefs sought therein. To highlight just one point, my Lord, and I will cite, Article 168 of the Constitution empowers the first respondent, the Judicial Service Commission, to consider removal proceedings against judges.
Sorry, Counsel, but
yes, ma'am.
You say these 2 letters constitute an action.
Yes.
Just letters alone or just letters with some? How does it constitute an action? So you need to tell us further. Those 2 letters constituted an action or an intervention of this court that can elicit an intervention from this court. On what basis would the court be acting on the 2 letters? You are not telling us.
My Lord, our submissions is that those 2 letters addressed by the Judicial Service Commission, an organ of state created by this Constitution, constitutes or can trigger a cause of action by the addressee, in this case Justice Smokin Wanjala, to this court for reliefs. That is our submission.
What were they inviting from the judge?
Yes, madam.
You are saying that the 2 letters can constitute an action, but you're not telling us on what basis would those letters be able to constitute an action that you can ask this court to intervene.
Along with that, from the judge, I was asking what you are asking the judge to do, because were they containing anything to say that we have evaluated or we are going through preliminaries that the GSA is entitled to do before we can invite the response from the judge?
These 2 letters.
So that we can raise the issue that could the High Court now jurisdiction be invoked because we have overstepped their mandate. That is the element.
Yes, tell us what was wrong with the letters.
My letters in question were forwarded petitions from, in the first case, petition number 35 of 2024, which was a characterization by the Judicial Service Commission that it was a petition seeking the removal of Justice Smokin Wanjala based on a complaint by Dari Limited.
My apologies, Councillor Kipogei, for interjecting.
Yes, ma'am.
So let's make it very simple. What is the violation or threatened violation of the Constitution by the first respondent sending your client those 2 letters?
on the first part, my lord, and I was taking the court to that point because of the argument which was made by Judicial Service Commission that these petitions were not tried. The second bit which I was going to take the court to is now an amplification of Article 168. What is the nature of a petition for purposes of Article 168? The first bit which I was dealing with was there an action by a state organ triggering a motion to the court so that the petition is right? So I was answering that bit which came from the respondents. Probably I jumped the gun. I should have allowed you to make that argument first. But was there action by a state organ? Yes, ma'am. And so consequently, the petition is right. Now, on the second bit, is the petition constitutionally filed? That takes us to Article 168, and that is where I'm going. My lord, Article 168 of the Constitution, Article 168 of Article 3. Okay, we can start with 2. Provides that the removal of a judge may be initiated by the Commission itself or on the petition of any person to the Judicial Service Commission. This is a petition which has been brought by, to quote the Constitution, any person. Now, and Article 3 says, a petition by a person to the Commission shall be in writing, setting out the alleged facts constituting the ground for the judge's removal. So that there are 4 elements which must be met by a person seeking to remove a judge, and that ties to the argument which were made by my learned friend Mr. Wong. The first bit is that it must be a petition seeking the removal of a judge. It must seek the removal of a judge. I will ask your lordships, when you retire, to look at the letter from my good friend Duncan Okach to the Judicial Service Commission and the attached affidavit. Nowhere in those 2 documents as the complainant sought the removal of Justice Smokin Wanyama and any of the 7 judges. It does not seek the removal of judges. It fails the first test in that article. So how the Judicial Service Commission characterized it, that complaint, to be a petition seeking removal, nobody knows. And that is the first threshold question which Ken Binoma was referring to, that they must satisfy themselves that the petition before them actually seeks the removal of a judge, because there can be many complaints, my lord. We can complain about whether these benches are sufficiently soft or hard. We can complain about many things to the Judicial Service Commission. Not every complaint sent to the Judicial Service Commission seeks the removal of a judge. And it is that first test which the court, the JSC must satisfy. They must satisfy themselves that there is a proper complaint before them. Before they even go to the grounds, does it seek the removal of a judge? And we are saying the complaint by Dari Limited did not. And because it was forwarded to the judges, before that threshold analysis was considered, is this a complaint for removal? And it fails. And for that reason, we've come before you to ask that you quash it. With respect to the correspondence in relation to the complaint by Nelson Abbey, we note, my lords, that it does seek, in one of the paragraphs in support of the complaint, the affidavit in support of the complaint, it seeks removal. But even that one fails the second test, which is that it should set out the facts constituting the grounds. 163.3 requires a petitioner to the court, to the Judicial Service Commission, to identify the ground pursuant to which they are seeking to remove a judge. And the grounds are in the Constitution in one. If they seek to remove a judge, say, on account of bankruptcy, they identify bankruptcy as the ground. And then now particularize the facts, set out the facts. What are the facts in support of that ground? Now, if you look at the petition lodged by Nelson Adi, it sets out gross misconduct and misbehavior as the basis for removal. But then in the affidavit in support goes to set out judgments. A decision rendered by the court in Geokem. Another decision rendered in another one. Decisions it doesn't agree with. It brings them to the Judicial Service Commission. What do those decisions have to do with gross misconduct or misbehavior? There must be a marriage between the ground and the facts. That petition fails it. It doesn't satisfy that test. And it's for that reason, my Lord, we say even the avid petition does not satisfy the requirements of Article 163, Sub-Article 3.
Please, Member.
In sum, my Lord, we submit that if the Judicial Service Commission had undertaken a proper analysis of the petitions before them, the complaints before them, they would have reached the irresistible conclusion that there were no proper petitions before them, and that there was nothing to be forwarded to the judges for their response. The Judicial Service Commission is not supposed to be a conveyor belt. In this case, they were. They acted as conveyor belts. They received, they simply forwarded. Despite the denials in their replying affidavit. If they had considered as they say, they would have rejected this as not petitions within the meaning of Article 168. We rely on for the rest of the grounds in the petition, we rely on our written submissions, and I rely on the arguments made by my colleagues. I thank you.
You mentioned this case on 15 May, when we'll be hearing the case on FINDA petition. You know the other case which is ongoing on the similar matters. That date will be giving the date for both judgment for the both set of cases, upon FINDA and this one. But meanwhile, we'll be working on this, you can see as a lot of material. But that day, I will give a date for judgment, together with that one of FINDA, on 15th May. So we mentioned this case that date. After submissions by the councils in that case, we'll give you a judgment date for both sets. Is that okay?
Much obliged. Thank you very much for giving us a hearing under very adverse circumstances.
Asante sana, council. We hope to meet that day, yeah? Thank you. Thank you very much.